Good morning, everybody, and welcome to another one of my estate planning videos. This is Gary Winter, the managing attorney at Lavex, and you can follow me at Gary Winter Law on Twitter. This is a video on estate planning specifically for separate property, and in particular, we're going to talk about separate property trusts and when to use them as opposed to just using a joint trust. I made the video to be advanced enough for attorneys. There's some attorney specific content in there, but instead of just making two completely separate videos where we also had a video for clients, there's a lot of basic content in here too. So clients, bear with us if you're getting into some detail that is more appropriate for attorneys, and attorneys, hang in there if you're hearing some basic content that might be more oriented to a client. Here's what I'm going to go over. The major issue is when we have a separate property that we want to benefit kids or family members from a prior relationship. So we're remarried, we have a step parent, and we're trying to provide for them, but we still want to give assets that were separate property assets to our children or beneficiaries from prior relationships. So first of all, we got to understand and keep track of the difference between community versus separate property. What does that mean? How does it work? And then blended families, when you have these his kids, her kids, and our kids, it creates all kinds of issues like this. And the solution is, first of all, to use a trust. But second of all, what we're talking about specifically in this video is when might we add on or do a separate, completely separate trust for husband and wife, or add a separate property trust to a joint trust. And what are the pros and cons of doing that? So that's what we're talking about. So first of all, let's get into community and separate property. We're a California law firm, so most of our folks in California are pretty familiar with community property because we're a community property state. But basically, community property is the default rule. It's 50-50 ownership, and California looks at marriage as a partnership, 50-50. And property that is acquired during marriage is presumed community unless an exception applies. And so these are some of the exceptions. These are probably the most popular ones. And you can acquire separate property either by having it prior to the marriage and then doing a prenup, or keeping your property and earnings during marriage separate by a prenup. There is such thing as a post-nup or a post-marital agreement that you did after you got married and move property back and forth, or sort of stipulate as to whether it's community or separate. Obviously, if you own property prior to your marriage, that's your sole and separate property unless and until you commingle it. If someone receives a gift or gives a gift, the donor can say, I'm giving this to you as your sole and separate property, even though you're a married person. And then inheritance is a form of a gift where you benefit your children or other people as their sole and separate property. And so the default in inheritance is you're inheriting assets as your sole and separate property. It's not automatically community. So these are the exceptions to the default rule, and this is how you might acquire separate property. Like I said, blended families really need estate planning. This is a theme that we're getting out there to the community and to our clients and our attorneys. I think most of the litigation that we see in our firm is surrounded around blended families that failed to plan. So they really need it. The tension arises over spouses that want to benefit their surviving spouse with, for example, income or assets for their lifetime, but they're not necessarily trying to disinherit their kids from a prior relationship. So this is, that creates that tension between, well, I want my surviving spouse to have access to these assets or income from these assets, but I don't necessarily want my kids to not have this property. So how do we do that? Well, trust-based planning is a great way to do it when we have a desire to hold assets for the benefit of a surviving spouse. And then when that surviving spouse passes away, then those assets can transfer to my kids from a prior relationship. If we don't do planning in California, so the default rule here is California law will say spouse gets all your community property, and then spouse and kids are going to split up the separate property depending on how many kids there are. So A lot of people don't know this, that if they don't make a plan, that their separate property does not go all to their kids. Some of it's going to go to their spouse. And that has created some really, really tough feelings in a few cases I've been involved in. So it ends up, if this happens and you have no plan at all, so no will, no trust, then and we're doing what we call an intestate estate, then the issue is what is separate and what is community, because the surviving spouse wants it to be community because they get all of that, and the kids want it to be separate because they get some of that. So blended families really need to do estate planning. They need to do a trust-based plan. There's AB trusts, but this particular planning tool that we're looking at today has to do with a joint trust for that blended family, but then taking your separate property and putting it into a different trust, a separate property trust. So let's take a look at that. In a joint trust, spouses make the trust together. And you can do this. You can have spouses, domestic partners make a trust together. With a will, and we'll go into this more in a minute, but with a will, that's individual. I guess there is such a thing as a joint will. I've heard of it, but I've never done one. I think people generally make their wills individually. It's an individual statement of where you want assets in your name to go. But it's very common to do a joint trust, not common to do a joint will. And when you make a trust together, so both spouses are the grantors, both spouses are the trustees typically, and both spouses are the beneficiary. For those of you who haven't gotten into those basic concepts as to why to do a trust-based plan, there's a link at the end of this video that you can look at that goes into what's a revocable trust. Also, we have some FAQ videos on our website on lovex.com that you can watch, and there's other videos in this series to go into that level of detail. But for purposes of this, spouses can transfer into a joint trust. They can transfer their community property, and that's going to be recorded on a list at the back called Schedule A. And they can also transfer their separate property, and those are recorded on a list at the back called Schedule B and Schedule C. Schedule B being husband's separate property, Schedule C, wife's separate property. So it's also not commonly known, except to attorneys, that when you transfer assets to a trust, it doesn't change its character. Character meaning community versus separate. So if you put separate property into a trust, it's still separate property, even though on title it might say husband and wife, co-trustees of the trust. So we just track separate versus community by listing it on these different lists in the back of the joint trust. So that all sounds well and good. That's very convenient. We can hold both of our property types in this joint trust. Why would we not want to do that? Well, we've had situations come up more and more frequently, and it's sort of the inspiration for this video, where certain spouses inherit property or are gifted property from their families that are sort of family assets over the years, like farmland or business interests or whatever. And when you have a joint trust together, and even though you're holding it on Schedule B or C, both of the spouses are co-trustees in it. And when the family goes to look at the deed on title to the land, or they look at the stock of the family company or something, they see both spouses are co-trustees, and they're like, hey, you know what? Love the in-law, but he doesn't necessarily, or she doesn't necessarily need to be involved in all of our family decision-making, or we thought that this was just family property. They don't usually know and understand that just the fact that we put the separate property into the joint trust didn't convert or transfer its character. So it's confusing. And also, people need to maintain these schedules up here, because that's the easiest way to tell. And those are often, as people do with estate planning, they procrastinate and they don't always maintain those schedules. So those are some of the downsides of having separate property in a joint trust. What's the alternative? Well, either spouse or both spouses can make a separate property trust dedicated to holding only their separate property. So in the instance where you have a joint trust with your spouse, you can hold your community property in that joint trust, and you can hold your separate property in a separate property trust. That is cool because it's simpler, and the separate property spouse is the sole trustee, so you don't have to worry about those family issues. You don't have to worry so much about maintaining the schedules. it's less confusing and it's a whole lot less likely to cause disputes. It is a little bit less complicated after the death of the first spouse too. They're just a little bit cleaner to have sort of, hey, these assets go to my kids from a prior relationship. And there's just no question about that. So that's kind of why people do separate property trusts. One huge issue, especially for attorneys, don't forget to amend or restate the pour-over will. Your pour-over will is a backup plan to your trust. And anything left outside the trust after you pass away, if it's in your name, we say it pours over, meaning it just, the sole beneficiary of your will when you have a trust-based plan is your trust. And you have one will as an individual, but you can have two trusts. You can actually have more, but in this context, we're talking about having a joint trust with your spouse and a separate property trust for your separate property assets. The weird thing comes up is what happens when you create a separate property trust and you don't amend the pour-over will. And this is the facts of Wilkins versus Nelson, which is a February 2020 case that I read that was sort of the inspiration for me doing this video, where an attorney actually prepared a separate property trust for a mom of two sons from prior relationship, and he did not look at or amend her will. And the will was a pour-over will to a joint trust with her husband. And then there was subsequently, after she died, there was a lawsuit between the husband, the stepdad, and the kids from the prior relationship over a rental property that was funded as a separate property trust. The good news is the court found that her statement of intent by having the separate property trust was enough, and that rental property did go and pass to her sons from prior marriage. But in any event, it probably took years to do so, and caused a lot of disputes and so forth with the family. So really quick, for especially for the attorneys, this is what a normal pour-over will looks like to a joint trust. Here you've got I so-and-so am making a will. Here's my wife's name, my children's names, all reference to my kids or to them. And then here's the pour-over provision. I just give all the residue of my estate to the trust that my wife and I made, and it's called the such and such trust. So this is what we would call the pour-over right here. And oops. So this is a normal pour-over will to a joint trust. And basically any assets left in my name after I die goes to this joint trust. Notice that it does not discriminate or distinguish between, I give all my community property to my joint trust, I give all my separate property to my separate property trust. So what would that look like? And this is, just to give you some ideas of what your will should look like. There's lots of different ways to do this. And so, I'm not saying our way is the only way, but you need to have something that looks like this. You got the same will provisions. And then down here, I have two children from a prior marriage. My wife has two children from a prior marriage. So we identify our different beneficiaries and we say, hey, you know what? Anything that I have that's community, I give that all to my joint trust. Anything that I have that is separate, I give that to my separate property trust, and they can hold that. So you have two different pour-overs here, one of community property, one of separate property, and it's very clear that if something gets left in my name, I have a dual trust structure here, and I've got that built out in my will. So again, the will and the trust are a match set. If you're going to have a will, a joint, and a separate trust, they need to be all matched up, and they need to refer to it this way. And if in the Wilkins case, if they had amended the will to reflect the fact that the wife had created a separate property trust, then that case would have never been at issue. So this is to give you some idea of what that might look like. All right, really quick, just a quick summary and wrap up. Blended families really need estate planning because you got his kids, her kids, and our kids. Also, if you have separate property, you really got to keep track of it. It's important to maintain its character as separate property if your intention is for it to be transferred, in a manner other than your community. Really, probably the most frequent time where we're seeing the benefit of a separate property trust is if a spouse has separate property and they want someone other than their surviving spouse to inherit it. In other words, I'm mom and I have a rental property, and I'm married to dad, but he's not dad of my kids from a prior relationship, and I want my kids from the prior relationship to inherit this rental property. The best way and the cleanest way to do that is to use a separate property trust and not rely on the joint trust, Schedule A, B, and C. Attorneys and clients, don't forget that your will and trust are a match set. Attorneys, it's easy to not recall that, but when you're looking at a trust and you're making amendments to a trust, don't forget to also look at the will and make changes to it accordingly. Clients, it's helpful to understand that estate planning is kind of holistic. Wills and trusts go hand in hand. Healthcare directives and power of attorney go hand in hand. And when you come in and say, hey, we want to amend our estate plan, it's just amending this one little thing. Well, often it's not, because things are sort of woven throughout the plan. And this is a good example where somebody comes in and says, oh, I just want to do a separate property trust. And that attorney in Wilkins did it for the client and didn't touch anything else of the client's. And it was very affordable at the time, and it was super inexpensive. Actually, I think they said the fee was $600 in the case. And so, wow, what was it worth to save a few $100 because the attorney didn't touch those other things? But how many thousands of dollars did they spend, or tens of thousands did they spend in litigation afterwards because they were looking at that case through the blinders that the client put on the attorney. So just be careful about hamstringing your attorney. Make sure you give them all the information that you possibly can, and understand that your estate plan is sort of woven together. Let's see. Yeah, last but not least, here's some resources for you. There's some links here. I mentioned this one earlier about understanding more about a revocable living trust. You can check out that American Bar Association website, or there's an article if you need to know more about community versus separate property. There's a nice web page on the Judicial Council site for California. Or if you want to get into more details of what I'm talking about here, joint versus separate trust for married couples, there's a nice article on Wealth Council for you. For attorneys, there's some code section references right here. There's also a nice article on CEB from 2011 that specifically addresses this, and more deep planning considerations than what I'm talking about in terms of tax planning and so forth. And there's the citation for Wilkin versus Nelson. Last but not least, here's some information. If you enjoyed this video, please like it, share it, give us a shout out somehow, either on Facebook or whatever. Or if you just want to connect, send me an email. Follow me on Twitter there at Gary Winter Law, or you can follow LawVex on Twitter at LawVex LLP. And our other links are there if you want to check out what we're doing. We do produce these videos for our attorneys. We want them to know and understand, and our staff to deal with these things. We also send them to our clients from time to time when they're considering these questions. But we also use them as a resource for the community. We want to help educate the community. It's one of our core values at LawVex is education. So please feel free to share the video, like it, so that other people can see it. And if you found something in here that was helpful, I hope you did. And tune in next time, or like I said, just give us a thumbs up. So thanks for watching, and we appreciate it. Have a great one.